Thank you, Flutura, for your kind words. Good morning, ladies and gentlemen. A very warm welcome to all of you on behalf of the Council of Europe, which is supporting this conference, and thank you for having joined us in Strasbourg. We are happy to host such an important event, which brings together so many of you active in the field of freedom of expression to explore and discuss the recent case law of the European Court of Human Rights in this area. Let me focus on the interplay between the Strasbourg Court's case law and the standard-setting activities of the Committee of Ministers. It is the responsibility of the Committee of Ministers to provide a policy framework for the protection of freedom of expression and media freedom in Europe through the adoption of recommendations to its member states. This policy framework would not be possible without the Court's case law. When the Steering Committee on Media and Information Society develops draft recommendations to member states for the Committee of Ministers, it embraces the case law of individual judgments and translates it into concrete guidance for all its member states. Therefore, the system of negative and positive obligations arising from Article 10 of the Convention, as spelled out by the Court, is reflected in these recommendations. Likewise, the underlying requirements of legality, legitimacy, and proportionality of restrictions imposed on freedom of expression, as well as those of procedural fairness. A good illustration of this interplay is the recent recommendation on the protection of journalism and safety of journalists and other media actors, which was adopted last year. This recommendation maps out the principles based in the Court's case law pertaining to prevention mechanisms, protection of journalist safety, and prosecution of crimes committed against them. It then goes beyond by providing policy and practice indicators for the member states, including guidance on how to promote the recommendation and raise awareness about its content. The interaction between the case law and standard setting is a two-way process. Our recommendations are considered by the Court as an important source for the development and refinement of its case law. For example, in the recent Grand Chamber case of Magyar Helsinki Bizottság versus Hungary, the Court ruled on whether and under what conditions Article 10 includes the right of access to public documents. Among the instruments on which it relied in its reasoning, it referred to the 2002 recommendation of the Committee of Ministers on access to official documents, which guarantees such a right. In the case of Delphi versus Estonia, the Court referred to the 2011 recommendation on a new notion of media in the interpretation of duties and responsibilities for Internet news portals. In another Grand Chamber case, Centro Europa and Di Stefano versus Italy, the Court relied on several standard-setting instruments of the Council of Europe on media pluralism, in particular, the 2007 recommendation on media pluralism and diversity of media content to set out the positive obligation for member states to adopt an appropriate legislative and administrative framework to guarantee effective pluralism. The consideration that the Court and the Committee of Ministers show for each other's work mutually reinforces their respective contributions and builds a coherent approach to the protection of freedom of expression. As regards our standard-setting side of the coin, the court's interpretation and application of various standards enhances our sensibility for issues of controversy in the exercise of freedom of expression. It also provides valuable feedback on how our instruments may be understood. This is in turn helpful in our reflection as to whether further standard setting should be elaborated in certain areas. The desired effect of this continuous interplay between the court's case law and standard setting is to create a system of principles and guidelines that helps the member states to implement rights and responsibilities related to the right of freedom of expression and other rights that may complement it or come into conflict with it. We all see how digital development is profoundly affecting the way information and ideas are being imparted, expressed, and shared. This technological evolution enables access to more and more information from different sources, but also raises many concerns. Consequently, the so-called classical topics of freedom of expression that will be addressed in the first panel, defamation, privacy, and processing of personal data, have acquired new dimensions. The wide reach of the Internet means that comments made online, including those with defamatory content, may have a much bigger impact than those published in the legacy media. The emergence of a vast range of new actors who act as intermediaries for the Internet raises a number of questions on their respective roles, rights, and responsibilities. In the Council of Europe, we are currently working on a new recommendation on such Internet intermediaries, which will hopefully be adopted early next year. We see that in journalistic work, digital communication may help to protect the anonymity and confidentiality of journalistic sources, provided that journalists are sufficiently trained in digital safety. It has also facilitated the activities of whistleblowers. Yet, whistleblowers' sharing of critical information is sometimes perceived as political action rather than of disclosure of information in the public interest, which can benefit society as a whole. Transparency of legislation and too broad powers of authorities are key concerns here, which we have the opportunity to discuss in the second panel, Investigative Journalism, Access to Information, Protection of Sources and Whistleblowers. The third and last panel in today's conference will address the right to protest and the role of the media during protests. That is, when journalists, and often also the subjects of their reporting, are the most vulnerable. Due to the enormous quantity of available information, which remains often unchecked and is uncritically reproduced, the watchdog function of journalists and other media actors is more important than ever. New technologies have brought immense advantages and no lesser concerns. These concerns are addressed in the Court's case law as well as in the standard setting instruments of the Committee of Ministers, and I'm particularly delighted that judges of the Court participate to this important event. And now our conference will embark on an in-depth discussion, starting with our first panel. I thank you for your attention, and I'm looking forward to hearing your views and follow your interesting exchange. Thank you.